No part of the following lecture material may be used without the express written consent of Rick Ramos or Contra Costa College. Hi, this is Professor Rick Ramos, and we are talking about burden of proof today in our legal aspects of evidence course. First of all, what is proof? Proof occurs when the prosecution and defense establishes a degree of belief concerning a fact in the mind of the trier of fact. An example would be how showing a videotape to the jury of the suspect robbing a convenience store would set the tone for their belief that the person actually committed that crime. The magistrate has the ultimate responsibility to instruct the jury on legal issues affecting burden of proof. And this is because an instructional error affecting burden of proof cannot be harmless, meaning that it can't be just ignored no matter how strong the evidence is for the defendant's guilt. These type of things can get a case overturned. Another way of saying burden of proof is who has a responsibility to prove certain facts in the courtroom on certain topics. Or another way to say burden of proof is who has a legal obligation to establish a requisite degree of belief about a certain fact. The easiest way to teach this concept to you is to divide it up by prosecution and defense. First, look at the burden of proof that's on the prosecution to prove. The first is criminal guilt. The 14th Amendment protects accused persons against conviction except when the proof of guilt is presented beyond a reasonable doubt. And that is the responsibility of the prosecution. In order to commit a crime in California, the law requires that the person either commit an act with intent or fail to act, which that would be considered criminal negligence, when there is a legal obligation to do so. A defendant in a criminal action is presumed to be innocent until proven guilty. In the case of a reasonable doubt whether guilt is satisfactorily shown, he or she is entitled to an acquittal, and this is under 1096 of the Penal Code. So the prosecution has to either show criminal guilt or criminal negligence in regards to a case. The next thing they have to prove is Corpusdelicti. They carry the burden of proof to establish that the elements of the crime occurred. In the crime of burglary, the prosecution must prove that the defendant entered a dwelling or other area specified in the statute with a specific intent, so they had a forethought, planned it out, to commit a theft or any other felony. In the crime of robbery, the prosecution must prove that the defendant took away the personal property of another from the person's immediate presence without consent through the use of force or fear. The third burden of proof area is search and seizure, confession, and Miranda issues. Anytime there are constitutional areas with regard to search and seizure or Miranda issues, these are dealt with in pretrial hearings, either 1538 or 402 motions. The burden of proof in establishing the legality of searches and seizures rests with the prosecution. For example, the prosecutor must prove the legality of detentions, consent searches, arrest searches, vehicle searches, etc. An illegal search triggers the exclusionary rule, and the evidence seized can be found to be inadmissible in court. The same thing goes with illegally obtained confessions from suspects. They may not be used in court later on. The fourth area of burden of proof is jurisdiction. Jurisdiction is the legal authority of a court to hear a criminal case and render a judgment. Usually a case is tried in the county or judicial district where the offense occurred. Sometimes multiple jurisdictions can hear the case. An example would be a burglary that occurred in Riverside County where the suspects were found in San Diego County with the fruits of the crime. It could be prosecuted in either county. The next example is really a good one. A Canadian vacationer was traveling in her motorhome through Southern California. While she was in Ventura County, the defendant kidnapped, shot, and killed her, then dumped her body in Santa Barbara County. Jurisdiction is satisfied if the trial was held in the county where the fatal injury was inflicted, where the party that was injured died, or where the body was found. Any of those places could be established as the jurisdiction. If a crime occurs in a public park situated more than in one county, like Lake Tahoe or Yosemite, the offense could be prosecuted in either county within the park's jurisdictional boundaries. Now let's shift to the burden of proof that the defense holds. The first one is self-defense. This is called an assertive or affirmative defense. In the case of self-defense, the burden of proof is on the defendant to prove that they took action to defend their life or the life of another. In the case where the defendant claims double jeopardy or former jeopardy, they have the responsibility to show that the case has already been adjudicated. An example would be a defendant who had already pled guilty to misdemeanor DUI could not be re-prosecuted for felony DUI arising out of the same incident. And that comes from Grady versus Corbin and from 1990. An example where double jeopardy did not attach was in People versus Scott 97, where the defendant raped the victim and then set her afire. The defendant was initially convicted of attempt murder and rape at the time of the initial prosecution, but the victim died, and the court was able to go back and go after him for murder during special circumstances. And the California Appellate Court ruled that the murder prosecution was not barred by the double jeopardy rule. One of the exceptions to double jeopardy is the dual sovereignty doctrine, which says that if a suspect commits a state crime and during that crime they also would commit a federal crime which might be similar in nature, for instance, bank robbery is 211 of the Penal Code. It's also covered under the USC Title 18. The FBI would be chasing you around. That you could be prosecuted in both courts, and double jeopardy does not apply. In the case where a kidnapped victim is taken from Arizona and brought across the state line into California, you would have also a felony because they brought somebody across the state line, so they could be prosecuted in both federal and state court. In the case of the Rodney King case, where Kuhn and Powell were acquitted in a California state court, they were recharged in federal court for violation of civil rights, and they weren't able to establish the burden of proof for double jeopardy. Also, civil forfeitures don't constitute punishment for the purposes of double jeopardy clause. There's no double jeopardy under the dual liability doctrine. An example could be a boss commits a rape against one of his female employees. Under the dual liability doctrine, he can be convicted of rape in the criminal courts and sued for the tort injury in civil courts. Great example again is the OJ case, where he's acquitted of murder, but in civil court they attach liability on him for the death of his wife. Just a side note, there are a number of examples for self-defense, and you can read those in the textbook. I've already spoken about self-defense. The seventh condition would be insanity. A person can be found not guilty by reason of insanity using the McNaughton rule, and the defendant has a burden of proof to present evidence to prove an insanity defense by a preponderance of evidence. The eighth is intoxication. We already know that intoxication is not a defense in most cases, and that involuntary intoxication, meaning that someone slipped them some drugs without their knowledge, is a direct defense to a crime. But if the defendant is claiming voluntary intoxication for the purposes of negating specific intent, or involuntary intoxication to show unconsciousness of act, then they have the burden of proof to prove these facts by a preponderance of evidence. Now let's speak really quickly about capacity issues, because the burden of proof in capacity under 26 PC can belong to either the prosecution or the defense. If the legal issue involves a child under 14 years of age and their ability to commit a crime, the burden of proof is on the prosecution to show the minor's knowledge of the wrongfulness of the act by clear and convincing evidence. If the capacity involves ignorance or mistake of fact, accident, or misfortune, acting under threats of menaces, unconsciousness of act, or the defendant is an idiot as defined by the law, the burden of proof falls on the defense. This was a really short lecture. You need to go into your study questions, and you should be able to answer them with the information I just gave you. I'm not going to go over them right now because it's just so short. You should be able to go back to the beginning and listen to it. Here's what my suggestion is for studying for this lecture. Get the study questions, get them in front of you, get a piece of paper, listen to the lecture, and as I answer them, you can write them in, use those as your study notes for this section because it is so brief. This is Professor Rick Ramos, and you'll be hearing from me soon. Have a great day.